Mr. Mortinger, you filed a motion to stop defendant's request for productions and admissions or to modify the schedule for discovery. That was filed on February 10th, 2025. Ms. Fletcher, you filed your objection to his motion on February 28th of
Correct, Your Honor.
2025. And that's the only motion pending at this time, correct?
To my knowledge, Your Honor, yes.
Yes, Your Honor.
Okay. Go ahead, Mr. Mortinger.
Your Honor, I would
Let me officially call the case. I'm sorry.
Okay.
Okay. It's in the District Court of Ellis County, Kansas. It's in the matter of the marriage of Russell Mortinger and Keegan Mortinger. May I have an announcement of appearances, please?
Your Honor, Russell Mortinger representing himself pro se.
May it please the court, Keegan Mortinger appears through counsel Heather Fletcher, appearance by Zoom.
Go ahead, Mr. Mortinger.
Yes, Your Honor, I would like to extend the deadline so that I may serve my own RFA and RFPs. I can do that tomorrow. This is not an extension to my answers to the defendant's party, and it's not extended to permit any other discovery. On January 7th, Ms. Fletcher stated that she would be doing interrogatories and business subpoenas and no mention of RFAs and RFPs. She sent them to me on the final day they were due, knowing that I would not be able to do the same. I have attempted to communicate with her in good faith since then, before scheduling this hearing. If granted, that would give Ms. Fletcher time, the 30 days from tomorrow that I submit them, to do the RFAs and RFPs. Yeah.
Ms. Fletcher.
Your Honor, as the court noticed, we filed our objection on the 28th of February, and we would just incorporate all of the information and basis that we included within our objection. We would ask that the court take notice of that today. I don't want to go through all of that. But what I will point out in general is that under KSA 60-226, the general provisions governing discovery, it specifically sets out discovery methods can be by one or more of the following methods: interrogatories, written production of documents, request for admission, and we are not bound by any limitation other than the statute and what the court may impose against us. So this argument that, well, we didn't say at January what we were going to submit, et cetera, again, we're not required to. And even if we did say, oh, we're only going to submit this, things change between then and when discovery cutoff was. So as long as what we requested was allowed under the statute, that there should be absolutely no argument regarding this. And I would point out that nothing in Mr. Mortinger's motion indicates that what we asked for or what we issued was not allowed. He just wants basically a legal do-over at this time. And if the court recalls, on multiple occasions, the court has advised him that he is certainly, allowed to retain counsel, and he has declined to do so. And the court has also reminded him more than once that he will be held to the same standard as any attorney going forward. And so he cannot claim that he should be allowed to issue or extend this deadline to allow for his own because, like he didn't know that he could issue these things. He's clearly smart enough to research the statutes, Your Honor, because he's issuing things. And another issue that I would like to point out is that in his discovery, that in his, whatever you want to call them, discovery, interrogatories, whatever it was that he titled them, he did not include any citation to statute, nor did he include any instructions with his request.
Your Honor, objection. We're not here to talk about my interrogatories that I submitted.
Well, yeah. Ms. Fletcher, I understand that. As to his request, today he's specifically requesting that he not have to respond to the defendant's request for production and request for admissions, or that he have an opportunity to serve his own request for production and admissions. He's also requesting that exchange occur at the same time, and that either there be no additional discovery that there be no additional discovery without permission of the court, and that he wants to keep the hearing on for scheduling on March 24th.
Right. And Your Honor,
So
we're going to
let's
we're going to
address
object to
those
each
issues.
of those. We are going to object to each of those. Again, what we submitted is allowed under the statute, and he has not provided, because as the court is aware, he attempted to bring this up at our last hearing, and the court said, if you believe for good cause that this should be extended, then you need to set that out in your motion, and if you can't agree with Ms. Fletcher, then, set it for hearing. He has not shown good cause as to why this should be extended. He did not supplement the motion that he filed to stop our requests for productions and admissions. He didn't supplement that. And so it's our position that his motion should be denied by the court in its entirety. He has had ample opportunity to do his discovery as he wanted, and we did ours as we wanted. We're each responsible for our own cases. My client has now incurred additional attorney's fees because we are, again, here for a hearing on a motion that the plaintiff has filed, and she has incurred attorney's fees in the amount of $500 as a result of this, and she is asking for the court to order him to pay those fees and to pay those directly to our office within 30 days from today's date, and that she be granted a judgment against him for this.
Your Honor, if I may.
Good morning, Your.
Your Honor, regarding the statute 226, when Your Honor asked at the 07 January hearing, Your Honor asked the court what type of discoveries we would both be doing, and Ms. Fletcher's response was interrogatories and business subpoenas. So I was under the impression that that was all I would be receiving. To go on, so disadvantages for me, I still don't know much about what's going on in this case and what she's going to argue. I presented in detail my motions, cited documents to support my facts. She's issued a general denial of my motion for custody and never filed an answer for my motion for contempt, nor any other document. So therefore, I really don't know her defense. I also, Your Honor, have less information in general being so far away, as Keegan monitors my communication with the boys and I cannot do the same. So I'm just requesting additional information to build my case before we get to the trial. To touch on the cost, Ms. Fletcher, my time is also very valuable. This is your job. I do this in addition to my job. Your discovery requests were broad, and I've spent the majority of my free time and every weekend working on them since I've received them, and I just finished last night. She refers to my time as free and emphasizes that I'm supposed to act like a lawyer, yet does not treat my time like that of a lawyer. No one's time is free, Ms. Fletcher.
Anything else, Mr. Mortinger?
That is all, Your Honor.
Anything further, Ms. Fletcher?
Your Honor, the only other in response to that I would have is that if the court grants an extension of this deadline and grants this motion as Mr. Mortinger is requesting, that will be giving preferential treatment to Mr. Mortinger and will be prejudicial to the defendant. And again, we are objecting to this in its entirety, and we would ask the court to deny this motion and that he submit his responses to us as required.
Your Honor, I have,
Mr. Mortinger,
yes, Your Honor.
you may respond, but respond to that last comment.
Absolutely, Your Honor. I'm prepared to send Ms. Fletcher all of my answers for her interrogatories and all of her RFA and RFPs today following this hearing. I, again, am just asking for that extension to do the same.
Well, Mr. Mortinger, on our hearing on January 7th, I inquired as to what kind of discovery the parties anticipated. That in no way cuts off the parties. The parties can do whatever discovery they deem appropriate. The purpose of inquiring is to set a calendar time. Parties anticipated they could complete discovery within those 60 days. Okay. You're complaining because you received a request for production and request for admissions on February 7th. Okay, that was still about 46 days out to the end of discovery, which gave you time if you wish to file request for production and or request for admissions, you could have filed those and she could have responded within the discovery cutoff. You haven't done that. To my knowledge, you still haven't done that. And now we're within 2 weeks of our scheduling conference. You haven't explained to the court why you haven't done that, or how that puts you at a disadvantage by not being allowed to do that other than some broad general terms. So the court's going to deny your request. The plaintiff does have to answer, and you've got your answers ready, and those need to be sent to Ms. Fletcher forthwith. Okay. You have not demonstrated to the court a need for your further discovery other than some broad terms, which the court denies. We're still scheduled for March 24th for scheduling. That scheduling conference is at 9 a.m. Okay. So, Mr. Mortinger, I'm denying your motion that was filed on February 10th. But Ms. Fletcher, I'm not going to award any attorney's fees this morning. You have an ongoing issue concerning that we will deal with at trial.
Okay,
Okay?
thank you, Your Honor.
Okay. Mr. Mortinger, make sure that your responses get to Ms. Fletcher as soon as practical.
Yes, Your Honor.
You've indicated you're ready to send those yet today.
Yes, Your Honor.
I think they were due today, Your Honor.
Yes, I've been communicating with Ms. Fletcher. They are in fact due today, and I'm prepared to send those via Dropbox that I've communicated with Ms. Fletcher.
Excellent.
Yep.
Anything further than today, Mr. Mortinger?
No, Your Honor. No, that is it, Your Honor.
Anything further today, Ms. Fletcher?
No, Your Honor.
Okay.
Journal entry, do you want us to do that, or how do you want us to do the journal entry?
Your Honor, I can prepare the journal entry.
We'll let Mr. Mortinger prepare the journal entry, submit that to Ms. Fletcher. If you can't reach agreement, you know how to do the Rule 170. Thank you all.
Thank you.
It's my understanding the parties have not been able to work out a resolution of the journal entry.
Yes, Your Honor.
Okay. I have both the journal entry and your proposed changes, Mr. Mortinger. As to your first proposed change in paragraph 3, your concern?
Your Honor, my concern with paragraph 3 is just some of the verbiage. The November and December journal entry was a little bit different in regards to the sleepover times. And then also, I don't believe it's specific enough for the weekends. If my parents were to take them after school on Friday, that shortens their time versus having the full allotted time on the weekends if they're getting them after school on a Friday.
Ms. Fletcher.
Your Honor, the journal entry from November 14th is correct. The court signed that on, I believe it was the 8th of January when that was signed. And it was very specific as to the times. And this journal entry, as we proposed regarding paragraph 3, the court, when we were there on the 7th, ordered that the weekend parenting time would continue as it was ordered previously. And so that parenting time is, or that visitation time is set out in paragraph 4C of that journal entry that the court signed on January 8th. It does not need to be restated here again in this journal entry. Mr. Mortinger is attempting to change or add additional orders that were not put in place. There's already a journal entry that covers this. It doesn't need to be restated. I tried to explain that to him during this process, and he continues on the hunt for this language. And it's not appropriate.
Your Honor, I just don't see the reason to exclude this specificity in the journal entry as I had submitted for my objection.
And Your Honor, the court was very clear the last time we were here that these were highlights, and the court signed off and approved the November journal entry. So there's no reason to add this language.
I'm looking at my handwritten notes from January 7th, 20 to 25. On the visitation, my handwritten notes show one afternoon, Monday through Thursday, after school to 8 p.m. each week, as can be arranged by the parents. Then 2 weekend days a month, 11 a.m. to 8 p.m. Can have some spring break time if can be worked out, because the father is not utilizing the spring break time. Those were my notes regarding the grandparents basically utilizing visitation in place of the father due to the distance of travel and his other commitments. So,
And Your Honor, the notes as far as the times, I do not have that in my notes anywhere. And I went off of what the court had already signed or already approved regarding from November. And that is what they were exercising. The 2 separate days is actually, my understanding, is what they've actually been doing. It hasn't been an overnight. So I went off of what the court was already approving from the November. And again, I don't understand why this keeps coming up. As far as the spring break, since the court brought that up, that I think that's in another
That's
paragraph.
in paragraph.
that's in the next paragraph, but in this paragraph 3, those are my specific notes regarding that issue. Do you have any objection then to the language that the parents are allowed time with the minor children 2 weekend days a month, as can be arranged between the defendant and the grandparents? These weekend days can be scheduled on separate days, 11 a.m. to 8 p.m., or an overnight, Saturday, 11 a.m. through
Sorry, that should
Sunday
be Sunday,
at
correct?
8 p.m. Ms. Fletcher, is there anything wrong with putting that specific language in there? That's in accordance with the notes I wrote down from our hearing on January 7th.
I'm just reading the paragraph here, and I want to make sure that it's what we had put. We had put the current temporary orders, allowed time. I just want to see how this is flowing. So the first part of the paragraph, where it talks about the sports commitments, etc., that is all approved, correct?
Yeah, he's not objecting to that, nor does the court think that's inappropriate. That looks fine. The only thing he's asking to change is the last sentence to specifically spell out that the 2 weekend days a month can be, separate days, 8 a.m., 11 a.m. to 8 p.m., or one overnight, Saturday, 11 a.m. through Sunday at 8 p.m. That's what he's requesting.
Right. And I think the problem that I have with this, Your Honor, is that, again, if I recall correctly, from November, the children attend church on Sundays. I think that was an issue that was brought up. And so, again, getting specifically, if I remember from the last hearing that we had, in the one in November, it wasn't specifically a Saturday through Sunday. It could be weekend. It could be Friday after school until
They could
Saturday.
do the option if it could be worked out. They could
Correct.
either have two separate day visits,
Correct.
which they would not have to utilize on the same weekend. It could be
Right.
Saturday, it could be two different Saturdays, two different Sundays, but the idea of the grandparents having what amounts to the equivalency of a weekend. If they do a weekend, it would be a Saturday morning, 11 a.m. through Sunday evening at 8 p.m. Obviously, they can discuss with mom as to church services, etc., and getting the kids to the appropriate church service on Sunday. But the parameters of the visit are 11 a.m. to 8 p.m.
On Saturday through Sunday.
Saturday through Sunday, or on separate days, 11
Right.
a.m. to 8 p.m. on a Saturday. 2 weeks later, it could be another Saturday, or it could be a Sunday. The idea is to get the kids with their grandparents a couple of days a month,
Right.
spend weekend time, and then during the week, one afternoon a week. It doesn't matter what day it is, sometime Monday through Thursday, from after school till 8 p.m., as can be worked out between mom and the grandparents.
Right. I think that was our issue, Your Honor, was the church. If I recall correctly, that was something that had been brought up, was the church attendance.
Your Honor, my parents have no issues with getting them to church service on a Sunday if need be. I was not under the impression that they were attending Sunday church service every weekend, but that wouldn't be an issue for my parents to attend with them or
Yeah,
get them to the church service.
if it's their custom to attend, then the grandparents should take them to the service they're accustomed to attending.
Absolutely, Your Honor.
Yeah. So with that modification, Ms. Fletcher,
I don't think we would object to that, Your Honor. I think that was the issue with the Saturday to Sunday.
okay. So the court will allow the plaintiff's language, obviously correcting it through Sunday instead of saying Saturday through Saturday.
Correct.
Yes.
Correcting
Your
that,
Honor.
and that the grandparents will cooperate in getting the children to the service they're accustomed to.
Your Honor, so on paragraph 4, just some of the verbiage, she had stated that I will not be exercising, and I was wanting to change that the verbiage to able to due to military commitments. It's not that I do not want to. I would love to go spend spring break with our boys, but I am currently unable to, just given work situation.
Okay, well, that's more of a semantics issue.
Okay.
And Your
And
Honor,
The bottom line is you're not going to be utilizing spring break. And again, we talked about if we can work it out, getting the grandparents to utilize some of that time.
absolutely. Then in the middle of the paragraph, if we could change it to will be allowed, my parents will be allowed versus may.
we object to that, Your Honor, because the court just said, if it works out, it's not a mandatory situation. She is not required to co-parent with his parents.
I agree with that, Your Honor. She is not, but also she will be working and will have to pay for childcare or have a family member or somebody watch the children. So I didn't see the issue, which I brought up in the January 7th hearing. And there was no argument or defense on the other side that would have been an issue.
Absolutely.
Hang on, counsel. Let me ask you. Is there some bad blood between your wife and the grandparents?
Absolutely, Your Honor.
Okay. Is she going to look for ways not to allow them to exercise some time with the grandkids?
She has not done that, Your Honor. She has, my understanding, and I didn't know that we were gonna get into this depth of this, but my understanding is that since the court ordered that the grandparents were allowed time with these children, she has cooperated with them and things have been worked out.
Yeah,
So I,
let me make sure you and I are on the same page, Miss Fletcher. I asked if there was bad blood between her and grandparents, and you said absolutely.
the experience from this summer, I'm just gonna leave it at that, Your Honor.
Okay,
That would be the issue.
okay. Your client's not opposed to the grandparents spending time with the grandkids as we've outlined.
No, Your Honor, she was here the last time and said that she would work with that.
Okay,
But the way he is wanting this to read is that it's mandatory that these grandparents have these children over spring break. He is trying to edge in to this journal entry the issues that he wanted to bring up at the last hearing regarding transferring his time to his parents when he's deployed. And the agreement is between the parties, the
right,
parenting time.
and Mr. Mortinger, again, looking at my handwritten notes, what the court said is that the grandparents can have some spring break time if it can be worked out because the father will not be utilizing. Okay. It's very hard for the court to micromanage and because I don't know what's happening in their life. I don't know what's happening in your ex-wife's life. I don't know what's happening in the grandparents' lives. Okay. So the idea is they have an understanding that the court wants the grandparents to have some visitation time since you can't exercise it over spring break. And I don't want to get into the semantics about why you can't. The bottom line is you won't be exercising it. So, the court is directing mom to work with the grandparents to try to schedule a couple of days over the spring break so that they can spend some additional time, additional couple days with the grandparents if it can be worked out.
Yes, Your Honor.
Okay.
So, Your Honor, is our paragraph 4 to remain as it is?
Right. And Mr. Mortinger, understand that, again, it's very hard for the court to micromanage every day of every week of every year, and the court doesn't want to do that.
Absolutely, Your Honor.
The idea is your ex understands, Keegan understands that the court wants these children to have some additional time with the grandparents over spring break. If it can be worked out, that should happen. If it can't be worked out, she better have a really good reason why it didn't work out. And she understands that. So, at some point, you have to take a little bit on faith that people will do what they're supposed to do.
I agree, Your Honor.
Because otherwise, now we're going to be sitting here talking about, well, is that going to be Monday, Tuesday? Is that going to be Tuesday, Wednesday? Is that going to be Monday, Thursday? That's up to them. I can't look into their lives and predict ahead of time to know what's going to work out. Keegan understands the court would really like to see these kids spend a couple of extra days during spring break with the grandparents. If they can work it out, work it out. If they can't, they better have a really good reason why they couldn't work it out. And she understands that, and Miss Fletcher will counsel her on that.
Yes, Your Honor.
So, the journal entries are not verbatim word for word. They are to accurately portray the court orders. But they don't have to be word for word verbatim.
Yes, Your Honor.
Okay. If you feel better, you could change that to the court finds that the plaintiff's parents are allowed instead of may be allowed. But it portrays the meaning. I'd like him to spend a couple of days over spring break if it can be worked out. So, okay,
So Your Honor, am I to leave it or change it? Because I don't want to get into a situation where if my client
if
has
you,
the opportunity to, if this
yeah,
doesn't work out for
yeah,
some reason,
let's change this, Ms. Fletcher. On line 4, starting that next sentence, the court finds the plaintiff's parents will be allowed. Okay,
okay,
to have parenting time with the minor children a couple of days during spring break, if it can be worked out between defendant and grandparents. And obviously, that includes that the days and the times will be worked out by mom and grandparents. So,
and Your Honor, I guess I'm just going to put this on the record here. I understand that they're already getting these children every week, and they're getting weekend time with these children. And again, if Mr. Mortinger is not going to be able to exercise his parenting time, I'm really having a tough time with grandparents also getting additional spring break time. If she wants them to go with grandparents during that time and it works out, I understand that. But if she doesn't want that, or if she has something planned of her own, I don't want her plans to have to be, well, I can't do that because I'm supposed to give them a couple extra days during spring break, even though they are not the parents of these children. It is undermining her parenting time.
well, understanding if he were closer in locale, you're aware that he would be having at least every other weekend and several days during the week.
Absolutely, Your Honor.
So
I have no doubt.
as grandparents, they're not getting every other weekend and several days during a week. They are getting what tantamouts to one weekend, 1 2-day period on the weekend, whether it be single days or a solid weekend, as can be worked out. So it's 2 days out of 8 or 10, depending on the month. And then during the week, they're getting one evening, not multiple evenings. So I'm not substituting the grandparents for the father. I'm giving the grandparents appropriate grandparent time because the father, due to distance, cannot exercise all of his time.
And I understand that, Your Honor.
If there's something over spring break, such as the kids have some kind of school program that they need to attend or something, and it doesn't work out, it doesn't work out. I'm sure you'll express to your client that it's the court's desire they get a couple of days over spring break with the grandparents. It could be the beginning weekend, it can be the ending weekend, it can be during the week, whatever works out for her.
Okay.
But there's no reason for them not to have a couple of days during spring break, because we do have the advantage of the children not attending school during that time. So it's the court's desire that the grandparents get a couple of extra days over the spring break if it can be worked out. But Mr. Mortinger, I'm not going to dictate the dates, the times, the places.
Yeah, absolutely, Your Honor. I agree. Not trying to specify that.
And again, I don't know if it can be worked out. If there's something that's happening over spring break that I'm not aware of that precludes this from happening, then it doesn't happen. Could be a blizzard all week. I mean,
Yep.
we don't know.
Right.
So,
I agree, Your Honor.
okay.
No issue with that.
So with those changes, then Ms. Fletcher, we have paragraph 4. Okay. Paragraph 6, you objected to, Mr. Mortinger.
Yes, Your Honor. The parenting agreement already states the parties' obligations for co-parenting. I just wanted to also have the specific verbiage about the health of the children, just that that information be shared, given what I brought up during the last hearing.
And Your Honor, again, this has been, and I'm just going to say this has become a pattern of Mr. Mortinger. When we were here in November, he brought up issues that day of, I believe it was the grandparent visitation and things like that was the in-person hearing. We then came back on January 7th. He brought a litany of additional new things that he wanted to address that day. And now, and one of those was the issue of the medication, et cetera. And the court, again, the court was very specific. It said the parents are reminded of their, obligations of co-parenting. And so he's wanting to, once again, get into these specifics. And it is, well, we do hundreds of journal entries a year, Your Honor. We review hundreds of journal entries a year. And I have now been back here twice in the last month and a half to settle journal entries that should have been very easy to resolve. But I'm getting 5 and 6 pages of objections to journal entries. And I mean, it's
Your Honor,
not verbatim.
Your Honor, I agree that I don't do journal entries as much. I'm just trying to capture and make sure that the verbiage is accurate of the honorable court from the last hearing. With that said, I know we have communication between Ms. Fletcher and I trying to work this out, and I don't feel like she has really engaged me on any of the specifics rather than just objecting to any of my objections. So I'm trying to work through her with this on these journal entries, and I don't believe she's acting in good faith and actually trying to work with me on them.
Okay, Your Honor, I'm going to respond to that one.
Well,
we have sent him.
Respond briefly, Miss Fletcher. Okay, we're getting into the weeds here, and we're getting into what I know is going to be a future motion that we're going to have to deal with. All we're doing today is hammering out the language on this journal entry. Okay, with that, keeping that in mind, Miss Fletcher, you may make your record.
Very brief. We sent him the original one on 1/8. He then responded. I believe it was on the 13th. We then sent him correspondence and revised the journal entry and sent it to him again on the 20th. He then responded back on the 24th that he still has additional objections, and I believe that objection was 4 pages. And we sent him a second revised. I think it was on the 29th. And so this has gone on and on and on trying to resolve this. Then we finally, I think, submitted it to the court on the 4th or 5th, Rule 170, because it wasn't getting resolved. So that is what I wanted to bring forth, is the efforts that we have made to try to get this done, because this is costing my client a lot of money. It's costing him nothing. He's pro se. So every time we come back here, or every time I have to read an email, which I'm getting emails from him on Sunday afternoons demanding that I respond by the next day, essentially 24 hours later. He is setting deadlines in these emails that I need to respond to him by this time or submit that. Each one of those is costing my client money. She's at work today. She could not take off to be at this hearing to settle this journal entry.
Well, you've made your record, Miss Fletcher, and Mr. Mortinger. If you have objections, you need to put them all in one. You don't just keep coming back and coming back and coming back. That's not how this works. She puts together the journal entry. If you have objections, give her your objections. See if you can hammer it out. If not, it comes to the court. The standard for an attorney to reply to phone calls and emails is within 3 days. It's not within 24 hours, okay? So you can't anticipate that because you have time to work on something, Ms. Fletcher has time to work on it that same minute of that day. Okay, so plan your correspondence understanding she can, a response within 3 days is considered timely. Okay, now
Yes, Your Honor.
back to the journal entry. The court reiterated to the parties your obligations of co-parenting. The court used as an example that, you know, when a child's taking medications, both parties need to know about it. If either party observes what they believe to be a side effect, they tell the other. This is a good example of the journal entries aren't not meant to be a word for word resuscitation of the hearing. Okay, I reiterated the obligations. I used that as an example. The parents know that. The parents, being reasonable people, should live by that. But we don't. If we put everything in the journal entry, each journal entry is going to be 10 pages long, and that's not the purpose. The purpose is to get the main points. It's like an outline of a speech. The main points that the court ruled on down, so the parties can refer back to it accordingly, and then move on. Okay.
Understood, Your Honor.
So paragraph 6 is fine. I reiterated to the parties their obligations. That's what I did. That's what it says. Okay. So number 7.
Your Honor, for number 7, I just wanted to make it clear that the defendant was making a claim of the vexatious litigation, that the court acknowledged it instead of the court acknowledges that I am, that it's more of her claim that I'm being vexatious.
Okay, there again, we're getting into the semantics and we're getting into the weeds.
Yes, Your Honor. I'm learning. Understood, Your Honor.
She's made a motion, it's pending. Okay. I acknowledge that that is pending. Okay. And then
Paragraphs.
you,
Oh, I'm sorry, Your Honor.
we're on paragraph 7. Ms.
Okay.
Fletcher. Paragraph 7. Okay. Then you started to bring up ongoing issues regarding the health and what's been happening, and the court informed you that if you wanted to file a motion in regards to that, you were free to do so. Okay. So again, comparing my notes to the journal entry, you know, number 7 is a fair recitation of what we did.
Was that all the paragraphs, Your Honor, that were?
That's all that's in his written objection.
Okay.
Okay.
So revise the paragraph.
Revise paragraph 3, including his language, and then the regarding the time and day, and throwing in the language regarding church services that they're accustomed to.
Got it.
Okay.
And then paragraph 4.
4, yeah,
Change that will be allowed.
will be allowed.
And if it can be worked out, Your Honor.
With the days and times to be worked out. Okay. So, and you leave in the language if it works out. Again, I'm
Right.
not going to micromanage Mr. Mortinger.
Right.
Keegan knows what I'm after.
Okay. Understood, Your Honor.
She's gonna deal accordingly with it.
And those were the only changes, correct?
Yeah, we didn't change 6. We didn't change 7. Those were the changes.
And I will make those changes, Your Honor.
On the yeah, that's the only changes.
Okay.
Okay. Now, Mr. Mortinger, I notice in the file that we also now have some motions that you filed, but you need to work with Ms. Fletcher and get those noticed up for hearing. Okay? If at
Yes.
all possible, if it's a short thing and the parties agree to deal with it, the court will deal with it when we have these hearings. But when we have a hearing on, for example, hammering out the language of the journal entry, that's not a time for you to be filing motions and proposals 1 and 2 days before the hearing.
I understand that, Your Honor. It was
That's
just
not,
oh,
that's not timely notice. Now, if you and Ms. Fletcher can work that out, fine. If you can't work it out, we'll have a hearing on it. But there has to be a timely notice so that one, Ms. Fletcher can prepare it, and two, she can make arrangements with her client to be here for that hearing. Okay, now, having said that, Ms. Fletcher, did you get a chance to look at the motions on the 10th and the 12th? Is there anything that we can take up today? Or would
Your Honor,
you,
I have not had a chance to actually fully review those. I mean, that I've had other hearings and things like that, but I know that it was regarding the discovery, and I will tell you right now that we will object to that and we will file a response to that.
Mr. Mortinger, she's entitled to do discovery.
I
Okay,
understand that, Your Honor. It was just unclear to me in the last hearing after she stated that she needed time to do the business subpoenas and then interrogatories that I did not know. And she never mentioned in any of our correspondence regarding the request for productions and admissions.
Your Honor, actually, I did
Well,
refer him to the statute.
she did it, and there again, you don't have to, for example, on the interrogatories, you don't have to wait till she sends you hers and you answer them before you send her yours. You can send her yours now,
Yes, Your
And he
Honor.
did.
okay?
He
And I
did.
sent those. I just did not know that I was allowed to do the request for productions and admissions. Otherwise, I would have submitted those with my interrogatories.
Yeah, this falls back to you're representing yourself,
Yes, Your Honor.
and that's a choice you're making, and that's fine. But you're held to the same standard as any other attorney. Okay,
Yes, Your Honor.
so the court, I believe, allowed, or we had talked about getting the discovery completed in about 60 days, as I recall.
Absolutely.
I'm
That was
just
the
going by
deadline.
memory here,
No, that was the deadline.
but we had agreed we could get that knocked out in 60 days.
Mhm.
So you have to govern yourself accordingly, okay? Now, if for good cause, something needs to be extended,
No,
first you contact Ms. Fletcher. If you two can agree, that's fine. Do an agreed order extending it. If you can't agree, file a motion and the court will rule on that. Okay, but that's how this works is first, an email to the attorney, giving her sufficient time to respond to it. It's not appropriate to send an email and an hour later file a motion.
Yes, Your Honor.
Give her time to
Maybe 3 days.
respond. Give her time to respond. If you guys can work it out, work it out. If you can't work it out, then the court has to get involved. Okay? So your motions are filed with the court. They're not filed giving Ms. Fletcher sufficient time to deal with those today. They're still on file. Okay? If you and Ms. Fletcher can't work it out, then notice it up for hearing. Okay?
Yes, Your Honor.
Okay. Anything else today?
Just one question, if I may, Your Honor.
What's your question?
Regarding scheduling, like what's going to be on the agenda for the scheduling conference. Looking back through the docket and my notes, the defendant never filed an answer to my motion for the contempt that I filed. And I read that an order to show cause must be served by a sheriff. When does Your Honor technically like issue that order to show cause for my motion for contempt in like the case timeline? Will it be an issue like for the scheduling conference.
Did you submit it for service?
So when I was in North Carolina, they submitted, I have a draft of it. They said that I needed to submit it when I was here in North Carolina. I looked it up for Kansas as well. And I can include that draft order to show cause. I just didn't know when it was going to be addressed for the contempt that I had filed.
Well,
Your Honor, the statute's pretty clear on how to proceed on that.
yeah, you give them the notice of it, and again, then you schedule it for hearing.
Okay, because when I first filed everything when I was back with the clerk's office, from everything from North Carolina to Kansas, the clerk's office said that Your Honor would discuss it at our temporary emergency custody hearing, and we got so wrapped up in the weeds that I totally forgot to bring it up. And I could, if I could, I would.
At the scheduling conference at the end of discovery, we will discuss and make sure we know what all motions are pending, what all needs to be heard, and set a time for hearing on the pending motions. Okay. The court does not want to piecemeal this. Right now, you're doing discovery. Let's get your discovery done. Okay.
Yes, Your Honor.
And by the time you do discovery and then by the time you negotiate, there may not be a need for that hearing. So let's take this one step at a time. If you have a motion pending, we'll discuss any pending motions at the scheduling conference.
Yes, Your Honor.
Okay, but let's not try to piecemeal this. Let's do this in an orderly fashion. Okay,
Understood, Your Honor.
okay. Anything further, Ms. Fletcher?
No, Your Honor.
Anything further, Mr. Mortinger?
No, Your Honor.
Okay, am I pronouncing your last name correct?
It's Mortinger, Your Honor.
Mortinger?
Yes, Your Honor. We kind of just rolled with it in the beginning, so
My apologies.
no
I
worries.
think I
Your
probably
Honor.
pronounce it different every time because I
Yeah,
wasn't sure.
I get
either.
it all the time. I kind of just doesn't even faze me anymore. So
My apologies if I'm pronouncing it wrong.
that's all right, Your Honor. I appreciate it.
Okay. And Ms. Fletcher, you'll make the corrections on the journal entry?
I will do that, Your Honor.
Okay. And again, Mr. Mortinger, she's going to submit it to you. If you
Yes,
can
Your Honor.
sign off, sign off.
Agreed, Your Honor.
Not sign off, she'll submit it Rule 170. If you have written objections, write the written objections, but any objections you have need to come in one email, not piecemealing that, okay?
Yes, Your Honor. I understand. I appreciate the explanation, and I don't foresee any objections given that we resolved this in today's hearing.
Okay, excellent. Thank you all.